Hello, everyone, and welcome. Thank you for joining Foley and Lardner for today's presentation. Before we get started on today's program, we would like to go over a few housekeeping items. Questions may be entered via the Q&A widget located on the left-hand side of your screen. Questions will be addressed throughout the program, time permitting. This webinar is being recorded for post-event viewing. If you experience technical difficulties, please refresh your browser or visit the webcast help guide on the bottom of your screen. And now I will turn it over to Mark Neuberger to begin today's presentation. Mark, over to you.
Thank you, Jenny, and welcome everybody, and thank you for attending today. My name is Mark Neuberger. I'm of Counsel in the Miami office and focus mainly on labor and employment. I want to walk you through how we're going to handle this today. As you can see, we have three other bright faces up on the screen who will be speaking to you. After some brief introduction by me, you'll hear from Katie Kelly, who's a public affairs advisor in our Tallahassee office. Katie will walk us through the details of the infamous law, also known as HB1, and go through it in detail because I think there's a lot of confusion and misunderstanding about what's in this law and what's not in this law. Katie will also briefly mention three other laws that were passed at the same time, HB 3, 5, and 7, for those of you who are counting, and then we'll give us a bit of a prognostication of what's going to happen. For those of you who are not Floridians, our legislature sits annually only for a very brief period of time, and our legislature will be going into session in early January for 2 months. And Katie's going to prognosticate what we may expect from our legislature in the next couple of months. Then we're going to turn it over to Kevin Hyde. Kevin is the managing partner of the Jacksonville office of Foley and Lardner, also practices in labor and employment. He has a former career in politics, so understands both the law and the political side of what we're all dealing with. Kevin will walk us through the timeline on the various vaccine mandates at the federal level. Kevin will then also try to walk us through the areas of conflict and overlap between the three federal mandates, that being the federal government contractor mandate, the mandate issued by the Centers for Medicare, for healthcare providers, and the OSHA regs. Now, of course, 2 of the 3 are state. We understand that, but we think it's important you know what the time deadlines were and how HB1 intersects with these other laws. Then we're going to turn it over to Kara Schoonover. Kara works in our healthcare section at practice and has been actively involved in working and assisting healthcare-based clients on trying to navigate through this morass. Now, with that, a couple of disclaimers from lawyers. Number one of the things we can't do today is give specific legal advice. Each of your situations is different and unique. We understand it, and today's format is not the way to do that. With that, we intend to have some open discussion amongst the 4 of us and include you through the question and answer chat. If you ask a very specific, very detailed question, your question won't get answered because we can't drill down to that. Number 2, we don't have all the answers to all the questions that are out there. This is a very confusing and rapidly evolving area of the law. By way of example, you will see some charts that Kevin will walk us through today, talking about the intersection of the 3 mandates in the Florida state law. Our colleague, Kate Pamprin, when she was helping prepare those charts last week, literally came into my office at 5 o'clock and said, Mark, the law changed 3 times today while I was working on these charts. That was not an exaggeration. That was the truth. And we understand you're all facing that and have a lot of open questions, but simply put, there's a lot of unknown answers here. We can discuss the pros and cons of strategies, and in fact, we will and intend to give you some ideas of what you can and should be doing given the current uncertainty that we face. So with that, I'd like to turn it over to Katie Kelly, who's going to walk us through HB1.
Thank you, Mark, and hello, everybody. As Mark mentioned, I'm Katie Kelly. I'm based in the Tallahassee office for Foley and Lardner. I'm a public affairs advisor, and I work with a team of 3 other individuals who are public affairs directors here in our office. So with that, I'll go ahead and get started. A little background information, as I'm sure many of you know, Florida is no stranger to the limelight, and we have been in the crosshairs of the nation when it comes to our approach for the ever-evolving coronavirus. Beginning in the summer of 2020, Governor DeSantis developed a hard-hitting phased plan to reopen business, fought school board mask mandates, and battled cruise industry and other federal regulations by passing legislation in 2021 to ban the requirement of vaccine passports. This November, Governor Ron DeSantis called for a special session for the legislature to consider his Keep Florida Free agenda. The joint agenda included House and Senate bills that rejected all universal federal mandates that infringe on Floridians' rights and protect people, parents, and businesses. The Keep Florida Free agenda tackled the following high-level provisions: a prohibition on private employer COVID-19 mandates, which includes fines, a prohibition on public employee COVID-19 vaccine mandates, and permits educational institutions from requiring students to be COVID-19 vaccinated. With that, I will discuss the pieces of HB1 that I felt were relevant to today's conversation in more detail. HB1 is the meat and potatoes, I guess, of the special session that we just went through. This tackles all of the different types of COVID-19 mandates, whether it's vaccinations, masks, and how it creates a framework for employees to make the best decision for their health and affirming the rights of parents to make the best healthcare decisions for their children. The effects of the proposed changes I've divided into about 3 different parts, starting first with the employer COVID-19 vaccine mandates. This expires, as you can see on the screen, June 1st, 2023. This bill prohibits private employer vaccine mandates. Employees can choose from a number of exemptions, which you can see there on your screen that are listed out. Those include employees being able to opt for periodic testing or PPE as an exemption. Employers must cover the cost of testing and PPE exemptions for those employees. And the bill also prohibits employers from imposing a policy that prohibits an employee from choosing to receive the COVID-19 vaccine. With those prohibitions, there are employer violations that come with that, as expected. The bill authorizes employees to file a complaint with the Department of Legal Affairs, which is housed inside the Attorney General's office, alleging that an exemption has not been offered or has been improperly applied or denied. That then triggers an investigation by the DLA to see if that complaint is valid. And if they do find it valid, they work with the employer to notify them to let them know that they have an opportunity to cure the problem. This also allows terminated employees to file a complaint with the same office, alleging that an exemption has not been offered or has been improperly denied, resulting in the employee's termination. And lastly, it provides that an employer who fails to comply with the exemption requirements and terminates an employee based on COVID-19 vaccination mandates commits a violation. Now, with those violations, kind of just went through a lot of those. I'm going to skip to the next. Fines are associated. So if the Attorney General finds that an employee has been improperly terminated, the bill requires that the Attorney General can impose an administrative fine on business. As you can see on your screen, for an employer with fewer than 100 employees, it's $10,000 per violation. Per violation, $10,000. For an employer with over 100 employees, it's $50,000 per violation. The bill prohibits the Attorney General from imposing fines on an employer that reinstates, prior to the issuance of the final order, a terminated employee with payback or back pay to the date that the complaint was received by the office. The bill also provides the Attorney General with some factors to consider when determining the amount of costs to be associated with this fine. And that's whether the employer was knowingly and willfully in violation, whether the employer has shown good faith in attempting to comply, whether the employer has taken action to correct the violation, or whether the employer has previously been assessed a fine for a violation, and other mitigating or aggravating factors that fairness or due process requires. The second major component to HB1 is the prohibition on public employee COVID-19 vaccination mandates. This section does a variety of things. Some of it's for clarity, provides definitions, as you guys can see, for COVID-19, educational institution, which has been defined as any institution under the control of a district school board, a charter school, a state university, a developmental research school, a Florida college system institution, Florida School for the Deaf and Blind, and a Florida virtual school. So it hits pretty much every major schooling institution in the state. It also defines governmental entity, which we can all kind of walk through ourselves, but just for clarity, it's any political subdivision, including the executive, legislative, and judicial branches of government, the independent establishments of the state, counties, municipalities, districts, authorities, boards, or commissions. So that hits another variety of governmental entities that are housed within our state. This also bans an educational institution or a government entity from requiring vaccinations of anyone, and that includes employees. This bill also allows DOH to impose a fine not to exceed $5,000 per violation. And they do have a link on their website that you can go to and report these violations, and then I assume they will get in contact with you and go through this process. The final big component of HB1 is educational mandates in response to COVID-19. This we kind of touched on a little bit in the beginning. Educational institutions cannot require students be COVID-19 vaccinated. School districts cannot enforce school pass policies. School districts, and this is a big one I get a lot of questions on, cannot quarantine healthy students. And this means that no healthy student should be barred at any institution because of a school board's policy. And that includes, if there was some kind of contact with COVID-19, but the child tested negative, those types of situations. And students and parents may sue violating school districts to recover costs and attorney's fees. With that, that is kind of the meat and potatoes of HB1 that I felt were relevant, like I said, to today's discussion. And we can go into those in more detail if you guys would like at the end. But with that, I'm going to move on to the other bills that were associated with this special session.
Katie, before you do that, we have a question, and I think now might be a good time. The question is that under HB1, can an employer require testing if the employee selects one of the available accommodations under HB1, i.e. medical, religious, natural immunity, pregnancy?
I believe so under the current law. But the employer would have to pay for it.
Okay. There's nothing in HB1 that says you can't do this, correct?
Correct.
Okay. Great.
Okay.
Why don't you take us through the others?
Absolutely. HB 3B is linked to HB1. And this bill creates a public records exemption for an employee complaint alleging a private employer's violation of state law regarding the employer's COVID-19 vaccination policies or practices. So basically, this just keeps everything protected. It's held by the Department of Legal Affairs until the active investigation is completed or ceases to be active. HB 5B is the Florida Occupational Safety and Health State Plan. This is basically our version of OSHA, I guess. This bill establishes that it's in the state's best interest to explore the development of a state plan that would benefit our businesses and our workforce and our needs as a state. This bill directs the governor's office to develop a proposal for a state plan to assure jurisdiction over occupational safety and health issues for government and private employees. This also allows them to designate or hire appropriate staff to develop the proposal. It directs other agencies to be enlisted for help should the governor's office request it. And lastly, it requires that the governor's office provide a report to the Senate President and the Speaker of the House by January 17th, 2022, which contains a timeline for completion of the proposal and an explanation of whether or not the governor's office needs to hire additional employees, consultants, or contractors to help with the development of this proposal. Lastly, on the special session front, you have HB7, which is related to vaccines during a public health emergency. Prior to November 18th, when this law became law, Florida state law allowed a state health officer to the authority to declare a public health emergency and establish requirements for such situations. That person was authorized to order an individual be examined, tested, vaccinated, treated, isolated, or quarantined during a declared public health emergency, as we have experienced in the last 2 years. This person was also authorized to order an individual to isolate or quarantine if the individual is unable or unwilling to be examined, tested, vaccinated, or treated. Lastly, the state health officer was allowed to use any means necessary to vaccinate or treat an individual. HB7 is very simple, and it removes the authority of the state health officer to do any of the above. Looking ahead to the 2022 legislative session, we do not anticipate much policy coming from the legislature. It's a redistricting year, which means they're going to draw the maps, which create their seats, and then they're going to end in March and then go all run for election. Aside from redistricting, they also are only constitutionally required to finalize a budget. So I don't anticipate a lot of stuff coming from the legislature, but in the event that it does, as far as this conversation is concerned, there has been one bill that was introduced last week during committee week, and it is the extension of COVID-19 liability protections for healthcare providers. This, I don't know if many of you are familiar with last year's legislation, but SB 72 and SB 74 created civil liability protections for individuals, business, government entities, and other organizations for health or for COVID-19 related claims. So this bill just extends those provisions until June 2023, which is in line with all of the other pieces of legislation we discussed. This bill was produced by Senate Judiciary Committee, and it passed Senate Judiciary Committee for its first committee stop, and we anticipate that it will probably sail through the Senate. And with that, I'm happy to take any questions or pass it on over to Kevin.
Well, let me do this. We have a few questions that are focused on some of the more technical issues of HB1. So let's address them. And Kevin and Kara, feel free to chime in here. Number one question, well, we have a couple of questions that go to the validity of requests for exemptions. And I think in general, what I would recommend is the Florida Department of Health website has on it forms that were created by the Florida Department of Health to solicit requests for each of the enumerated exemptions in the statute. If you've not already looked at those as an employer, I encourage you to do that. You will find those forms to be de minimis. They require very little information from the employee in order to meet the test of an exemption. For example, we had one question in the chat about how do you prove an exemption based on immunity. If you go to the website and you look at that form, you basically see 3 potential boxes to be checked: PCR, antigen, antibody, and then you attach a copy of the test results. That's it. Similarly, on the religious request for exemption, it's very de minimis. I have a religious request, and you sign it and date it. The question arises whether an employer is required to use the forms by the Florida Department of Health. That's a complicated one, because if you are also subject to any other mandate, and right now the only viable mandate that might impact is the federal government contractor mandate. Those other mandates have more onerous requirements for someone to meet an accommodation. Any of our speakers want to comment on this?
Yeah, Mark, this is Kevin. With regard to the exemptions, it's fair to say that very little information is required, as you suggested, and the employer should not get into the business of trying to test the sincerity of their religious belief, for instance, to play doctor with regard to the employer, to the employee who's claiming the natural immunity. It is meant to be a very low threshold to meet the exemption requirements, and you don't want to find yourself in problems with the law because you are trying to challenge one of the exemptions.
Another question related to the administration of HB1 is, how do we know who this applies to, right? With people working remotely, people moving interstate, how do we know who's covered? And the law is not real specific. It just talks about employers. Anybody want to address that?
Yeah, that is the challenge. Obviously, this is a Florida law, so it deals with Florida employers. But to your point, Mark, all of the language that talks about the prohibitions on vaccine mandates, et cetera, says a private employer, implicitly one in Florida. So if you were a private employer operating in Florida, but if you have remote employees operating out of state, I would still say that you are a private employer in Florida covered by this law, and those remote employees would be covered. So you're really looking at the place at which your business is operating. And again, I would take a fairly broad view out of it. If you're in Florida operating, even if your employees are working remote, I would consider them to be covered.
Okay. Kevin, you want to pick it up from here?
Sure. Let's talk about we're going to start a discussion on the interplay between the Florida law and the three laws which are currently in place. And as Mark's indicated, there's some legal challenges and stays already into that. The reason I want to show you this is because we don't know what exactly is going to happen with the various legal challenges to the federal laws. So you need to be ready to implement your policies and to come into compliance with the federal laws should they come back into place. So this timeline, real briefly, and I know everyone can read it, goes back to the beginning of September when the president issued the executive order on federal contractors. And again, basically what this one does is if you're a federal contractor doing business either as a prime contractor or a subcontractor, you are subject to a federal vaccine mandate. November 5th, you have the ones related to the OSHA emergency temporary standard, as well as CMS, which covers healthcare providers receiving Medicare payments. November 6th, the day after, there was a national injunction by a federal judge blocking the OSHA standard. And as we sit here today, and it's only for today's purposes, that standard still remains blocked. It is currently being reviewed by the Sixth Circuit Court of Appeals, which is going to be looking at the OSHA standard for across the nation application. Next, as was just talked about in the special session, the governor of Florida enacted by his signature on November 18th the Florida statute, which we just talked about. Then on November 29th, a federal judge, I believe it was in Louisiana, enjoined the CMS standard. I'm sorry, it wasn't Louisiana, in certain states, in 10 states. And then on November 30th, the day after, you had the other 40 states blocking the CMS standard. And so you see that you now have the OHS standard and the CMS standard subject to being stayed as we speak. The executive order for federal contractors was also stayed or enjoined, but only in 3 states on November 30th. So, looking at what comes forward, recognizing there are stays at least of 2 of the laws and a partial stay of 1 of the laws. December 6th, which was yesterday, that was the date in which employers were originally required to comply with the CMS application. January 4th was the date by which employers were supposed to comply with CMS and the OSHA emergency temporary standard. And then January 18th, the date by which the employers were to comply with the federal contractors. So we have some dates still in the future by which the laws were to take place, and we don't know exactly what's going to happen with regard to whether the injunctions will remain in place or whether they will be lifted, but wanted you to have the idea of thinking about compliance on a going forward basis as we get into January. Now, some of these, and I realize this chart may be a little bit hard to review, but what we tried to do here was to put a side-by-side comparison of the Florida law compared to the federal law, and you'll notice wherever it says not available under either 2 or 3 of the federal laws, that is those places, and we'll go over them, where the Florida law is broader than the federal law. In the other areas, we'll notice the differences between these The reason to put all of this together is to understand there is a conflict between the Florida law and the federal law, and we'll talk about at the end about suggestions as to how to compare all of the laws and to come to some way to potentially comply with them. So, as was already indicated on the top line, the basic rule in Florida, no vaccine mandates unless you provide exemptions in the testing requirement is available as well. Under the CMS, you must require the vaccine, unlike Florida, which prohibits the vaccine unless there's a specific exemption, which would be the religious or medical exemptions. Same thing under the federal contractor. Vaccine mandate unless the medical or religious exemption. Under OSHA, it's an either or a vaccination or weekly testing. Under the medical exemption, you'll notice it's a little bit different. We had the previous question about how much can you challenge the medical exemption. In Florida, it merely says it's the best medical interest as attested by a healthcare provider, a very loose standard. Whereas under the CMS standard, it's the exemption has to be based on recognized contraindications. For instance, a person who has a particular disease that would make it harmful for them to be vaccinated. Under the federal contractor standard, it's more of one akin to the ADA or Title VII if the person is legally required to a reasonable accommodation. The OSHA standard is similar to the CMS standard. And I realize I'm going over these fast, and if there's questions, we can talk about them during the question period. One of the big differences here under the religious exemption that you'll see is Florida takes a much broader view of what a religious belief would be. The other standards under federal law follow the basic federal law that if it's a sincerely held religious belief, but it doesn't talk about a moral or ethical belief. It talks about a religious belief. The Florida law talks about in its administrative rule a moral or ethical belief. So it's a bit broader standard there as well. Probably the loophole, if you want to call it that, the area of exemption that is the largest under the Florida law is that a person who is pregnant or anticipated pregnancy or who is of childbearing age can claim an exemption from any vaccination requirement. And so obviously that affects women of a very broad swath there. And it's only that they fall within one of those characteristics, not necessarily any proof of what the intention to become pregnant is or what a childbearing age is. So it's a very broad standard. And you'll see that those exemptions are not available under any of the federal law. Also, you'll see, as we talked about briefly, the natural immunity exemption, that if you have a positive diagnostic test recognized by the FDA that you've already had COVID or positive antibody test, that's an exemption from any vaccine requirement. Again, that exemption is not available under any of the three federal laws. With regard to the employer-provided PPE, one of the exemptions that Florida recognizes that a person can be exempted from vaccines if they agree to wear employer-provided PPE. It is not, that exemption is not available under two of the federal laws. It is available in OSHA, but combined with weekly testing. So I think what you'll see again there is Florida's much broader in its exemption. As Katie already indicated, under the next, the periodic testing exemption, the employer must pay for the testing if it's required of the employees. Testing is not an available option under either the CMS law or the contractor law. In the OSHA law, it is the employee who must pay for the testing, and the employee must also agree to wear a mask during that period of time. Under the federal law governing OSHA, there is an outdoor working exemption where you can be exempted from the vaccine requirements. Florida law does not mention it. It's not available under the CMS or the federal contractor law. Likewise, Florida does not mention any teleworking exemption, whereas OSHA does, that if a person's working remotely via telework, they would not have to be tested. Same thing under the CMS law. Under the federal contractor law, that exemption is not available. I realize we went through that fast, and Mark, maybe we should take some of the questions, see quite a few of them popping up, but I wanted you to see the areas of conflict between the federal law and the Florida law and how they might overlap with one another.
Yeah, here's a good question. Given the governor's various public statements that the law is intended to protect current and employees from termination, what's the panel's view on the scope of HB1 with respect to new hires and job applicants?
It's strange because the law does not address applicants, and it specifically uses the word employees, and it does talk about termination, which you can only terminate an employee. So a conservative reading of it is to say it only covers employees who are currently employed and not applicants. I hesitate only from the standpoint we may see some administrative guidance on that, but as written in the statutes, it talks about employees, which in my mind at least refers to incumbent employees.
I tend to agree with you on that, Kevin. Trying to look through here and see. We've gotten some questions that go to the interplay between the federal mandates and the state law and, what us lawyers would call a preemption issue. If OSHA or CMS were to pop back up alive, do you want to talk about the conflict between federal and state law?
Yeah, the federal laws, I can't remember if it's all three or which one specifically, they specifically state that they preempt state laws which are in conflict. And there you get into a basic constitutional question about federal laws preempting state laws. And candidly, that's the challenge that's presented where there's conflict between these laws. As Mark has indicated, right now that conflict doesn't exist because some of these laws are stayed. But I think the correct answer is the federal law will prevail over state law if challenged.
And Kevin, this is Katie. CMS does allow for the states now, what their consideration process is, I don't know, but it does allow the states to comment on their rule by January 4th of next year.
Okay, very good.
So I think that they're, just from my understanding, that with the federal rules and the state laws, there seems to not be a lot of consultation with the states. So this feedback period just for CMS, might facilitate some of that.
Yeah, that's a possibility. Mm-hmm. And of course, the Florida law is largely a reaction to the three federal orders or laws or mandates. And so you can see that there is a natural tension there already. And of course, Florida has challenged in court some of these laws.
If there ever were litigation, some people have said, though, that what they would argue, if they were seeking to support the Florida law, they would argue that the Florida law was legislatively enacted and signed by the governor, whereas all of the federal mandates are only administratively issued. The three of them, or the CMS and OSHA, were issued under an emergency procedure which bypassed the normal administrative procedure requirements of issuing regulations. So that's another argument that makes the tension between state and federal less certain. When I went to law school, federal trumps state, but it's not always that clear. And there are arguments the state law could survive in the face of a federal regulation.
Yeah, and for instance, with regard to the CMS, that was some of the arguments Florida advanced before the 11th Circuit Court of Appeals, which at least yesterday or the day before issued an order refusing to enjoin the CMS going into effect. But that issue is going to continue to be litigated.
Kara, you want to add some comments from the healthcare side?
Yeah, so I'll talk a little bit more about the interplay between the CMS mandate, particularly in the Florida law, particularly since right now kind of the healthcare industry is trapped between a rock and a hard place. So to kind of bring us back to the beginning, the CMS IFC applies to very specific healthcare entities that are required to follow the conditions of participation. So we think usually hospitals, long-term care facilities, rehabilitation agencies, and skilled nursing facilities. And so as Mark, Kevin, and Katie all said before me, the Florida law is currently the law of the land, as the CMS mandate was enjoined by 2 courts last week. But in light of these decisions, CMS appealed and concurrently released guidance to state surveyors, instructing the surveyors that they cannot look at these entities for compliance with the CMS requirements. So therefore, the healthcare industry can take a little bit of a deep breath that they only have to comply with one law right now, but the future remains uncertain as we're still waiting to see how the CMS mandate will be upheld on appeals. If the CMS mandate comes back into effect, as we kind of already talked about, there are some potential preemption arguments between the CMS mandate and the Florida law. To give you an understanding about what CMS says about preemption, in the IFC, they specifically said, to those covered by the mandate, CMS intended this to preempt any inconsistent or conflicting state and local laws. And I think that they have the authority to do so based on the Constitution's Supremacy Clause. The preamble goes into a little bit more detail about what CMS thinks is inconsistent or conflicting. On the big picture side, CMS says that this is intended to preempt any state laws that would prohibit covered employers from requiring their employees to be vaccinated by COVID-19. Then on the exemption side, which is specifically relevant to Florida, CMS allows exemptions for medical and religious accommodations and specifically said that broader exemptions are inconsistent with the mandate. So the question comes for Florida, what should healthcare employers do about the 5 Florida-specific exemptions that are not included within the CMS mandate and are likely to be perceived to be broader than what CMS allows? Not only for themselves as the covered entity, but as those in the healthcare industry know, this CMS mandate indirectly covers a whole gambit of vendors. And so it's hard to tell what to do when you're indirectly covered by CMS and directly covered by Florida law. As of right now, this is kind of all hypothetical because we're waiting for the courts to kind of come to their decision. But we do recommend that healthcare entities to continue to get in place all of their policies and procedures required by CMS, taking this extra time to make sure things are in place and done correctly. That way, if CMS mandate comes back tomorrow, the next day, or even a month from now, our healthcare employers are ready and can act quickly to implement the mandate on an unknown timeline. So Mark, I'll pass it back to you.
Yeah, well, and that you just answered a question that we got. What should we be doing? And you've answered it from the CMS perspective. But if you're not a healthcare employer, Kevin, but you are, let's say, have more than 100 employees, Kevin, what would a OSHA-covered employer, what should they be doing today?
Yeah, I think that the wise and safe thing to do is to look at the requirements under OSHA and think about what you can do short of actually imposing the mandate, collecting information as to who's already been vaccinated and the other things required by the law in the event that the stay is lifted and the law were to go into effect, so that you would be ready to do that. So you're walking up to the line of the mandate, actually imposing and requiring people who are not currently vaccinated to be vaccinated, but doing those other preparatory things that you can do so that if the law does come into play, you will be able to quickly implement it. Mark, what is your view on that?
No, I agree. And, whereas if you're a federal government contractor now subject, you do have to comply with that or you risk losing your contract. And in fact, to be covered, you have to sign an amendment to your government contract. So you agree to do this. And you can't just hide behind the Florida law and ignore those obligations that you contracted to undertake.
Yeah, one thing you should.
One of the other. Yeah, go ahead, Kevin.
I was going to say, if you are employed by an entity that has received a letter from if you're a contractor to someone who sends you, quote, the clause, wanting you to certify your compliance with the mandate, you then, as Mark suggested, do have to decide whether you want to continue to be a contractor for that entity that is paying you from federal funds. And so that's when the employer has to make a decision at that point. But it is not, there's not nearly as much latitude as there is with other laws because with the exception of certain areas, that law is in place.
Another question we got is, what if people volunteer to give you their vaccine card? Number one, I think you need to draw a distinction between employees and non-employees. As Kelly mentioned early on, Katie mentioned early on, we passed an anti-vaccine passport law that applies in certain cases. It does not apply to employers asking for vaccine cards from employees. And therefore, as a matter of policy, you have to decide, are you going to survey the vaccination rates of your workforce? And if so, how are you going to do it? Are you going to ask people, or are you going to say, show me the card? There is nothing as such in any of these laws that prevents a Florida employer currently from saying to its employees, I want to see your card. And if you don't, I'm going to have to require you to utilize certain PPE, distancing, and other protections. Anybody disagree with that?
No, I think that's right.
No, and I think
it's. Go for it, Katie.
With the vaccine passport requirements, I think the crux of that is that you cannot deny entry to your patrons from coming into your business if they don't show a vaccine card. But yes, like Mark said, I agree with him. Your employer at your own company can impose those mandates on you and then give you the alternative to wear the mask or isolate or whatever the options are.
Yeah, and what Katie's specifically referring to was an even prior Florida law that prevented those vaccine passports. But that's relating to your customers that want to do business with you. It did not address employees. In other words, an employer can require the employee to inform of its status. Mark, there was a question about can we solve all of this just by doing a testing policy across the board? And the Florida law does not prohibit the employer from doing testing. And so many of these conflicts that we've been talking about, the employer can still do testing and maybe get to some of the same knowledge that they might have as to the employee's current status by doing a broad testing program.
Except if you're covered by the OSHA ETS. Of course, right. If you're covered by the contractor, there was no testing option afforded to federal government contractors.
Exactly. Yeah. When we speak of the OSHA because it's the 100 employee requirement, that's going to have the broadest application of the three federal laws. It's not healthcare specific, and it's not dependent upon receipt of federal funds through a federal contract.
I did put into the chat list the link to the Florida Department of Health website where you can see the COVID vaccine exemption forms. That's www.floridahealth.gov. And then you navigate to the press release that was issued on November 18th, 2021. And that's where you would see the link to all the forms, as well as the regulation that was issued by the Department of Health following the passage of the law. Scrolling through the questions, anybody see one we missed? So question, does the anti-vax passport law apply to a job site or customer site where our employees work and they require proof of vaccination? I think what they're saying here is my employees have to go onto the work site of another employer, and that employer has said, in order to come on site, you have to be vaccinated, and I want to see the proof. Anybody want to address that question?
I think in that situation, the other employer who is asking the employee of another entity to come on site, they can't ask for that vaccination. That would not violate the passport law because that employee is not coming to that other site to receive the goods or services being sold by that entity. If you give you a real simple
is
example,
likely a requirement under CMS as well. If it comes into effect, any vendors that come on site, CMS covered entities having a requirement to track and securely document all vaccination status.
Yeah, give you an example. If I own a restaurant under the Florida the vaccine passport law, I cannot tell you as a customer that I want to see your vaccine status in order for you to come in and purchase a meal from me. But if I'm the food service guy delivering it to you, I could ask that if I'm the owner of the restaurant. Does everybody agree with that?
Yes.
Yes.
Related to that, we've had questions about. Well, no, I think you addressed that question. Here's another one. If we have tenants in our building, what are our obligations to the tenant if we don't require vaccines? If you as the landlord have, let's say in a commercial office building, you don't have a specific requirement to require vaccination, then it's really, unless there's something in your leases that say a tenant can't prohibit, it's up to the individual tenant to decide what their protocols are and how they're going to administer it. And the question references, well, some of our tenants are medical offices, and I think as a landlord, you have no specific obligation either way because you're not an employer, and all of these federal mandates really only apply in the context of an employer-employee relationship. So as a landlord, you would have no specific obligations, and you would leave it up to your tenants to decide what to do.
Yeah, I agree. I mean, I think about our building and, as requirements began to get a little bit more lax, you talk to other firms and they have to wear a mask all the time. You see us and we have our own little disclaimer before you walk into our office. So it does seem to not be uniform, and at least in our building, as an example, of what you can and cannot do.
Someone asked if a private company was subject to a mask mandate, how would we enforce it? Well, I think you enforce it the way you enforce any other rules of conduct in the workplace. You tell people what you expect, and ultimately, you counsel, you discipline, you warn, and if necessary, potentially terminate for not following protocols. That would potentially run afoul of the Florida law if the person was subjected to one of the exemptions. But if they're not within the exemption or not following general PPE requirements, then I don't think there's anything in HB1 that would prevent you from ultimately terminating a non-compliant employee. Anybody on our panel disagree with that?
No, I would agree with that.
The termination, the penalties for termination under the law really flow from the unwillingness to grant an exemption, right? So under the law, people have these 5 different exemptions, and the employer has to allow them. If they don't, that's when an employer gets into trouble. But there's nothing in the law, and arguably one of the exemptions is I'll follow PPE and therefore I won't get vaccinated. So that suggests that the HB1 recognizes the employer's right to continue to use PPE, social distancing, and other healthcare protocols to control the spread in its workplace.
And that as an alternative to requiring vaccines. And so it's not saying that it's a complete absence of any precautions.
And a follow-up to what we were just talking about is the question was, but how would the government enforce it? So let's take a look. The OSHA ETS is on hold. That does not eliminate OSHA's statutory obligation to enforce workplace safety rules. And those of you who are familiar with OSHA know two things. One, OSHA is one of the most broad federal employment laws that exist. You may know that many employment laws have thresholds, 15 for Title VII, 20 for age discrimination, 50 for FMLA, 100 for WARN. OSHA has no employee threshold limit. It applies to every employer. And in OSHA, in the OSHA law, is what's known as the General Duty Clause that allows OSHA to enforce workplaces that don't provide a healthy and safe workplace for all of its employees, because under the General Duty Clause, every employer has such a legal obligation and has had it since the law passed. So even before OSHA issued the ETS, you may know, they were going into workplaces, they were conducting safety audits, and they were finding people. You know, early on in the pandemic, we read about meatpacking plants and other workplaces. I had a number of clients who got various complaints about COVID requirements that were filed with OSHA prior to any ETS or any vaccine mandate. So none of that goes away, and that still exists. Next question, can an employee claim an exemption after confronted with non-compliance? So what I think the questioner is asking, that's a good question. Employee doesn't comply, and the employer begins to take some sort of discipline, and then all of a sudden pops up and says, yeah, I need an exemption. I fall into one of the 5 categories. Panel, what do you think?
That's the I suddenly got religion question. You know, I'd be really careful about, again, at least under the Florida law, the way the exemptions are so broadly defined, I would be very careful about suddenly questioning that exemption just because of the timing with which it was raised. And that, I will admit, that is a subjective opinion. We'd have to see how it's ultimately determined, but again, I would just be careful about challenging the person's exemption.
I agree, because of the broad nature in the way this law is structured.
Right.
Next question, does the Florida law address if an employer being responsible for any side effects or medical issues resulting from the vaccine? I presume what this questioner is asking is, if I mandate the vaccine and somebody has adverse side effects, am I liable as the employer? Panel?
I'm trying to read the question here.
Number 35.
I'm sorry. I'm not too worried about that one. I mean, because what we've seen is a trend to not holding employers responsible as a result of COVID liability.
I agree. A couple of things. Number one, it's always hard to prove causation. Whatever adverse consequence they're suffering, they'd have to prove came from the vaccine and came from the fact the employer mandated it. Number two, if all those facts lined up, arguably, you have a workers' comp defense, and the claim might be covered under workers' comp. Now, you know, everybody winces when we say workers' comp, and employers roll their eyes and go, oh, geez. Workers' comp can be your friend in cases like this, because under workers' comp, if it's a compensable injury, they can't sue you in tort. They can't get unlimited damages. They can't get pain and suffering. They can't get compensatory and punitive damages. They can't get loss of consortium. They're limited to wage loss of about 2/3 of their average weekly wage up to a maximum, and 100% of the medical just for that injury. That is a great limiter of liability right there. So, you know, the questions, it's not easily answered, but the likelihood that I think an employer in Florida would get hung for something like that are pretty slim.
Yeah, I think so. Mark, there was a question of whether the OSHA ETS standard, assuming it ever went into play, whether it covers federal contractors. It may, but there are just two different analyses. The OSHA ETS standard covers any employer with 100 employees or more. The federal contractor standard talks about those that receive federal monies. So it's likely that many federal contractors will also be covered by the OSHA standard, but you have to measure it by the number of employees to see whether the OSHA standard applies.
Another great question here. The HB1 does not specifically provide for a private cause of action, right? An aggrieved employee's remedy under the statute is to file a complaint with the state investigates, and if they find the employer liable, the state fines. Right now, as the law exists, you can't sue your employer for an HB1 violation, although we've seen some lawyers out in the community seemingly acting as if they have that. What would happen if an employee filed a lawsuit in state court or federal court under HB1?
Well, I think if you were defending that claim, you have a very good statutory argument to look at to say the legislature knew how it wanted to provide remedies for employees who were terminated and violated the statute, and it specifically delegated to the Department of Legal Affairs, therefore excluded the private rights of actions or other things. I think from a statutory argument basis, you've got a very strong defense there.
Katie, any sense from what was percolating through the legislature at the time?
No, I mean, I agree with what you guys said. I don't think it's much different than that.
And I do think there was some concern about this becoming an open season for the plaintiff's bar to bring additional claims against employers, which I think is one of the reasons you have specified penalties and you have a specified agency to review the claims and administer the fines that might come about. So while the penalties are high and the possibility of a fine is there, it is within the parameters of who's going to handle it, what the limits are.
And it provides those considerations. I mean, it's not like the AG can just willy-nilly say you get $50,000. Right. You know, there are factors that her office has to consider before even providing that violation or that fine. So, I mean, I think there are some protections there for employers as well.
And along those lines, the law specifically provides that if the employer fixes the problem before they get fined, they basically get out of jail free card, meaning if you fired somebody improperly, they file a complaint, the state begins to investigate,